Hi everyone, Massive Human Rights and Freedom Initiative welcomes you to these awareness lectures. We thank those who are present and those who are not present, who may be watching this through the social media. We thank you for watching this in advance. We thank you also for subscribing. We thank you for listening to us, and we hope you will utilize these very awareness lectures to your own personal use and to help others who do not know or who are not aware of what is happening within the society. As you watch this, we ask you to share them and let others, your friends and well-wishers, have clue of these particular awareness lectures. We thank you and hope you will listen and listen attentively. Share to your government officials and those who are in authority for them to be aware also that the activities and whatever they do are taken care of internationally, not only nationally or domestically. Thank you and continue listening.
On the issue of torture, the Human Rights Committee Against Torture, in pursuant of Resolution 39/46 of 1984 under the Human Rights Council, Massive Human Rights Initiative will look at some analysis of laws and the practice relating to prosecution of crimes when criminal challenges are deemed malicious or abuse of process by prosecutors raised under universal jurisdiction. Before we continue, we will remind ourselves of the international commissions of inquiry, commissions of human rights, and fact-finding missions and other investigations. The United Nations mandated commissions of inquiry, fact-finding missions, and investigations are increasingly being used to respond to situations of serious violations of international humanitarian laws and international human rights laws, whether protracted or resulting from sudden events, and to promote accountability for such violations and counter impunity. It is noteworthy to note that the international investigative bodies have been established by the Security Council, General Assembly, the Human Rights Council, and its predecessors, the Commission on Human Rights, and the Secretary General and the High Commissioner for Human Rights. In this lecture, you will realize that both Hague Law and the Geneva Law identifies several of the violations of each norm. In the last lectures or awareness, we mentioned the Roman Statute of International Criminal Court. This very statute, the Geneva Convention of 1949, has been ratified by all member states of United Nations, including Nigeria. However, in the case of Nigeria, the Committee Against Torture is only interested in the issue of the Convention Against Torture and other cruel, inhuman, or degrading treatment or punishment of 1984. Like we stated last week, the Committee Against Torture commences its inquiry on its own motion. The broad rights protected in these conventions include the right to life and due process, freedom from discrimination and torture, and the freedom of expression and assembly. However, the right to self-determination and the right of persons belonging to minority groups are protected by the Convention on Civil and Political Rights. In addition, The UN has established a range of organs and mechanisms to protect human rights, including the Commission on Human Rights. This means that the Committee Against Torture is the watchdog of any abuse on human rights. In today's awareness, we are going to look at the issue or case between Nnamdi Kanu and the Nigerian government on the issue of criminal trials and the appeal that is scheduled to begin on 13th September 2022. The legal team of Nnamdi Kanu notified the public that the appeal number CA/ABJ/CR/625/2022 between Nnamdi Kanu versus Nigeria have been scheduled from 11th day of October 2020 to 13th day of September 2022. Amongst the interested groups and the public desiring to hear more about the case included the Human Rights Council, human rights activists, and other public interest groups, as well as massive human rights initiative. All are interested to note what is going to happen on this very date. Before we continue this very awareness, we will listen to one of the speakers and other vital video clips before we continue the analysis. Like indicated,
and automatic. Let us turn now to the rules on attribution, knowing that they are really at play when actual conducts, rather than omissions, occurred. The rules on attribution are customary rules of international law that are part of the secondary rules on responsibility codified by the International Law Commission. A careful study of the rules on attribution is not only needed in order to understand what attribution is about, but it also helps us to understand more concretely what states or international organizations are. Let us concentrate on attribution to states, knowing that the rules on attribution to international organizations are not very much different. The basic rule on attribution is very easy to understand. A state is responsible for the conduct of any of its organs. Article 4 of the Articles on State Responsibility for Internationally Wrongful Act recalls that, I quote, "An organ includes any person or entity which has that status in accordance with the internal law of the state," end of quote, and that it does not matter, I quote again, whether the organ exercises legislative, executive, judicial, or any other functions. End of quote. In other words, states are internationally responsible for the conduct of their governments, but also for the conduct of their legislature or of their courts and tribunals, despite the constitutional independence of the latter. For instance, in 2012, in a case between Germany and Italy, that we will address later in the course, the International Court of Justice found the Italian Republic internationally responsible for judgments of the Corte di Cassazione. Moreover, under Article 4 of the Articles on State Responsibility, it does not matter whether the organ of the state is a high-ranking official, a minister, for instance, or a low-ranking civil servant, or whether it is part of the central government of the state or of a decentralized entity or even a municipality. The state can be held responsible for the conduct of any of its organs, instrumentalities, or officials which form part of its organization, whether or not they have a separate legal personality under internal law. The basic rule on attribution of the conduct of state organs helps us to understand that as a subject of international law, the state is one single entity, and it presents itself as a unity for the purpose of international responsibility.
Thank you very much. You can understand this very illustration. The state has its own organs, and the Minister of Justice, judges, police or security agents, governors, their commissioners, every other personality that is employed by state government or national government of Nigeria may be held responsible for any act that jeopardizes the actions and the rules and regulations of international law. Let us continue and see what all these attributions of the personalities in Nigerian state, especially those who are influencing the decisions of other officers. The officers that are controlled by the government will also be held responsible for their decisions, for their actions, whether they are advised by friends, by interested groups, or whosoever. They may be also held responsible.
Some of the issues in this very appeal raised included the issue of the prosecutors placing many charges against the leader of indigenous people of Biafra, and also the countermeasures from the defense team, and as a result, some of the counts were removed. In this very case, there have been allegations of interferences by the federal government, interferences by the Minister of Justice, interferences by the DSS. All the measures has to show that there is associated malicious and abuse of process. Massive human rights initiative and freedom for the people has, in fact, reviewed some of the issues associated with malicious or abuse of process by any prosecutor, especially federal government of Nigeria. But the interest wouldn't have been there purposely, but because it is associated with human rights abuses and violations against humanity, torture, and enforced kidnapping. This might have attracted the interest of Human Rights Council and other human rights groups. In most cases, some trials attract public interest, and international communities like United Nations Human Rights Council, Amnesty International, and other human rights groups, including Massive Freedom and Human Rights Initiative. In this awareness, we will look at criminal malicious prosecution. In some public interest cases, when the accused identifies and shows that some charges against him or her are dropped due to lack of merit, complaints of malice, and abuse of process. Well, abuse of process must have emanated or must be emanated from the actions of the prosecutors, the judges, the people prosecuting the victims, and all whatnot. Then before we continue, we will look at the subjective elements of the internationally wrong act, especially during the time the officers involved in any wrongful act. And this is a lesson to those who are in authority in Nigeria and the state governors and their actors. They must listen to this very clip and listen carefully, for future reference will be made towards their actions they took while in authority. In this very awareness, we will look at the abuse of process and constitutional contest. The tension between executive and judiciary in the context of claims of executive impingement on fundamental human rights recognized by law, such as can occur in the context of application of abuse of process doctrine. This will be inevitably impacted upon by the legal character of those fundamental rights. There is an array of internationally recognized civil and political rights that are constitutionally enshrined in Nigerian Constitution. Any application of abuse of process doctrine in a criminal case in Nigeria will therefore generally raise issues as to the role of constitutional rights. In Nigeria, the constitutional impact left with some important constitutional expression and the express of protections as part of the judicial discretion to stay proceedings, particularly relevant constitutional rights to help establish perspective of the well-established categories of abuse of process, included the right to personal liberty, freedom from cruel and degrading treatment, freedom from unreasonable search and seizure in the house of a victim. The relationship between torture and corruption has impact in administrative justice of Nigeria. It has been observed that corruption and the torture and other ill-treatment are indeed linked. This has been established by both the Human Rights Committee in the resolution of 19th March 2018 on the negative impact of corruption on the right to be free from torture and other cruel, inhuman, and degrading treatment or punishment. This is because corruption is associated with the judgment or the programmed decisions of some courts and as applied by some judges, of which in these very lectures there have been allegations of malicious persecution based on hatred of some issues. There has been time that some of the ethnic nationalities pronounced hatred against the indigenous people of Biafra and Nnamdi Kanu. When the statistics of issues and utterances of some Fulani ethnic group shows that there is a hatred on not only IPOB but on its leader. These utterances and the publications by this ethnic group shows the impact of the decisions of the court, purely because the prosecutors, the president, the Directorate of State Security, the director, the judge in charge of the case, the Minister of Justice in charge of the state, and the associated complaints of MACBANS against IPOB and Nnamdi Kanu shows that there is indeed malicious prosecution and influenced abuse of process, especially when the president has been accused on several occasions and the executives of interfering in the proceedings of the case of Nnamdi Kanu. And this has been, in many occasions, been pronounced and made open by the legal team, both national and international. The respect for the rule of law, not just by the citizens, but also by the state itself. In this sense, the criminal law values achieving accountability cannot hold where the executives and the judiciary, as well as the prosecutors, have animosity against their victims. The protection of individual rights. The criminal law operates in the context of a free and democratic society, and its concerns for accountability is generally tempered by respect for individual rights. In this situation, there has been none. Fairness and equality before the law. Perhaps the most important manifestation of this underlying value is fair trial principles. Fair trial principles applies where there is no abuse of process or malice against the victim. It is seen below in most cases that a stay of proceedings is the likelihood to guarantee a free and fair trial where the abuse of process and malice has been identified not only by the legal team but also by the public as well as other international human rights groups, even the Council Against the Torture of Human Beings and Undue Punishment. There are categories of abuse of process in Nnamdi's criminal case proceedings. Massive Human Rights identified 4 separate categories of abuse of process in this very case. Proceedings that are meant to inflict an unfair trial on the accused. The proceedings that are vexation or oppressive and would therefore be unfair in a broader sense. The proceedings that are brought for a collateral purpose, and the proceedings that are otherwise meant to bring administration of justice into dispute. All these have been identified, and in the case of the Human Rights Act, there is a provision for the protection of fair trial, right to a fair trial that begins and concludes without unreasonable delay, the right to consult with legal practitioners and be represented fully. An independent, impartial, competent, and accessible system of justice is required for a free and fair judicial justice. is to be accepted as one of the norms, and the equality of the same right given to the prosecution should also be given to the accused. Human rights, dignity, and the respect for individual, personal, and integrity, including the responsibility, good governance, and the limitation of interference. That is what makes the legal system honorable. Therefore, the implementation of the rule of law principles at national level is also part of the acceptance of any judicial system. However, this appeal does not indeed appeal to the international human rights group, especially the Committee Against Torture under the United Nations Human Rights Council. They are only interested in the release of Nnamdi Kanu as requested in accordance with the CAT Resolution 39/46 of 1984. Without that fulfillment, there is a trouble for the actors. That is why this video clip was or is played in these very awareness lectures or exposition for those who are in authority, and those who take decisions should note that their decisions can be used also against them at international court when it is necessary to do so. With that, we come to the conclusion of this very awareness.
They said that there never would be any indictees.
Nisam kriv I nisam učestvovao ni u jednom od djela koja mi se stavljaju na teret za optužnicu.
And then they said there would never be any trials.
Malheureusement, nous n'avons qu'une salle d'audience et donc nous devrons la partager avec les autres procès qui sont en cours. Le tribunal est très chargé en ce moment.
And then they said there would never be any convictions.
Vous êtes donc coupable, général Krstić, de génocide.
And there would never be any sentencing.
For the foregoing reasons, the appeal chamber imposes a sentence of life imprisonment.
Nearly 25 years later, the International Criminal Tribunal for the former Yugoslavia is proud of having dismantled the tradition of impunity for war crimes around the world.
The message now is much clearer, as I said. There's no longer impunity. And this is, in my opinion, the greatest, the most fundamental, the most important legacy of the ICTY.
Thank you very much. You can as well realize that impunity is being destroyed. There is no place for impunity. That is why this is being played for those who are in authority, for those who take decisions, for those who manipulate issues, for the judges. We have made it known through the first video for every one of you to take note that Nigerian reluctance to take decisions by themselves does not mean that the others cannot do so. The international community is now watching Nigerians and their actions based on the issue of Nnamdi Kanu. Nnamdi Kanu has brought to open the international and the national judgments and the comparisons. That has opened the eyes of many people who care to know. That is why these lectures or awareness is being brought for those in authority to change their mind, for those in authority to know that there is also authority that is greater than theirs when it comes to complaints and the international community. Those governors in southeastern state, impunity is being destroyed at international level. Anyone that may be caught through complaints may face the same as those who committed one international crime or the other. Torture is on the table of Nigerian government against Nnamdi Kanu. Order has been given. New human rights chief has been announced, while the former is retiring. Therefore, everyone has to sit up and act in accordance with the rule of law. With this, we come to the end of this awareness, and we ask everybody to have a share, to watch this. For those who have already have awareness of this, for those who have already been part of these very lectures, we ask you to share them, give us a thumb, and subscribe to this channel. The channel's purpose is to bring lessons and awareness that the state government, the legal system, may not be able to make known to the public. Massive Human Rights and Freedom Initiative has taken it upon itself to make this aware, or make this awareness open, not only to Nigerians, to Africans, and the world at large. Massive covers every part of human rights abuse and have the authority to make it known to the world and to the world body where they can take decision against the abuser. With today's, we come to the end of it. God bless you all for listening. Share this video, give us a thumb, and subscribe. Once you subscribe, you encourage your friends to subscribe, and you will get the full-fledged lectures anytime we come on air. Thank you very much, and God bless you all.